Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom. One of our members and listeners' main fears is having a very expensive divorce, property settlement, or children's matter agreement. This episode is how to avoid that very expensive divorce, the 5 main things that you can do and to watch out for. Thank you, Mum.
Hello, Laura.
Hello.
Hi, everyone.
Now, before we start, every month we choose a lucky reviewer to get a free chat with you. Mm-hmm. And today it is Burn Fish. 57.
Oh, okay.
Via the Apple Podcasts. And it's titled Ping Pong Letters, and they gave us 5 stars. Yay.
Oh, lovely. Thank you.
This podcast came as a breath of clean air. I have been listened to but not counselled by my solicitors and paying thousands for letters they only wanted to play ping pong. Finally, an expert telling me exactly where to look, what to expect, and it hasn't cost a cent. Thanks, guys. You're both helping millions of Aussie women. So I don't know if we're helping millions.
But maybe some.
Yes, but thank you, Burnfish. So definitely email us at thedivorcecourspodcast@gmail.com and we'll arrange that free call for you with Mum. Yep. And if anybody else would like to write a review, we'll be choosing one again next month.
Yes.
To also win. So, and we really appreciate people writing in because the more reviews we get, the more our podcast gets pushed to people. So,
and the more people who need it.
Who we can help.
Help. Yep.
Thank you so much. All right, Mum. So we're talking about ways to avoid super expensive divorces. So before we start giving the 5 things that people really need to watch out for, what kind of prices have you seen happen to people? Or are there cases that everyone talks about in court? They're like, holy moly, that was expensive.
Yes, there are a few cases where the people have been in court for years. And I'm thinking of the case of Strawn. It was a published case, STRACHAN. And that they released a few million at a shot each time for the wife to pursue her case. And the court had some terrible things to say about the lawyers and the proportionality of spending so much money as the pool was diminishing by the end of it. I don't think they were fighting over as much as they'd already spent in legal fees.
Wow.
So, yes, you need to keep it. And there are cases where you think, how did that get so big? How did that – there's a modest property pool, and how did they use all their money? And do you know, Laura, they're saying in the statistics with the family courts that 22% of people are self-represented on the first court date, but 39% of cases have at least one self-represented litigant by trial.
Wow. And
that means to me that people are wasting money on the early stages and then have run out by the time it comes to the very important thing, and they have to represent themselves. And often they're using their lawyers to do things they could do for themselves.
Right.
So, yeah.
So that's something you've got to watch out for because it looks like I didn't even know it was possible to spend millions and millions and millions of dollars in court fees. But that's terrible.
It is.
Right. Okay. So don't let that be you.
No. I mean, even if you've got a $30,000 property pool and you spend 10 on litigation, that's madness.
Yes.
You might as well have settled it and, saved the money for your kids. Yep.
Okay, everyone's situation is different though,
of
so
course.
Always get legal advice, but
general advice only. Yes.
All right, so number one thing that you see makes people's divorces expensive or their property settlement is about getting the facts. So can you tell everybody listening today what should they be doing so it doesn't rack up the bills?
Ping pong letters, that's what Burnfish, our lovely listener, said. That's exactly what it is. Ping pong letters. Tis, tidn't, did, didn't. Oh, I think it was this, you think it was that. No, stick to the facts, get the proof. For almost every important assertion you make in property settlement, like whether it's a point about what you had at the beginning of the relationship, what something was worth when you bought it, all of those things can be proven by documents. And if you don't have the documents anymore, you can find someone who still has the documents, your previous conveyancing lawyer. Ask your super fund what you had at a certain date. All of those things. And the minute you can produce a fact, then the whole argument disappears.
A fact with evidence.
Well,
So you can't argue evidence.
It's no point tisn't, because neither of you is going to persuade the other. So they say this is what happened, you say that's what happened and here's the proof.
Yes.
And then that issue's just put to one side.
Yeah. And we've always talked about legal letters and how expensive they are because the lawyer has to read it. The lawyer then has to charge you for that. Then they have to write a draft letter.
Yeah.
And that they have to charge you for that. Then they have to send it to you and they have to charge you for that. And then you have to read it and get back if there's any changes.
Yes.
And then they have to send it to the other side. And
Who may respond.
If you've got ping pong letters going on, that is a lot of dollars.
No matter how short the letter is.
Yes.
It still costs the same. Really, usually they cost at least a minimum of a 6-minute unit.
Yeah, which is roughly
a tenth of whatever their hourly rate is.
Wow. So that's like if their hourly rate's $500.
It's $50 for the letter to you, the letter back to them, the letter to the other side, the letter, it's just all it just adds up. And really, it's stuff you can probably do. So think about that. Think about what work you can do and find the proof. It's worth emptying out your filing cabinet or checking everything online or going through your phone and finding something that proves your point, because it's lovely how that issue just disappears.
The minute you get that hard proof. And we've talked about in webinars before the 3 types of lawyers you can have, and you can have the first class ride, which is probably what those Strawn people had, they sat in the aeroplane and they don't do anything. They don't drive the plane. They don't look at the maps. They're just enjoying it and they go along. Not that they're probably enjoying it, but you can also do that step in, step out approach.
Where you do some of the work.
Where you can do some of the work.
So if there's a tisn't letter, you can say to the lawyers, you know what, I've got that proof. I'll find it this weekend.
Yeah.
And it could be an odd bit of proof. Like I remember once there was an argument about a car and my client said, no, that was bought new for me for my birthday. And they said, no, it wasn't, just bought. She found a photo of her with the car with a big bow on it.
Yeah.
And the beauty of them nowadays is if they're digital photos, they've got date stamps.
Yes.
And sometimes, because we're all only human, sometimes your recollection might be wrong.
Yes.
And it also is good for you then to find the proof and go, oh, I could have sworn it was something else. And then you can say, okay, sorry, I'll concede that point. And again, boop, the point disappears.
And that would save you money if you've completely got it wrong and you're arguing it till you're blue in the face for the next 3 days. That could really be,
Well, it might be the reason you don't settle. You might be another, $20,000, $30,000, $40,000 in legal fees until someone finds the proof.
So your job is to keep your fees down, get that proof, and always find the evidence. And if that involves you having to go through the whole office from top to bottom to find it, do it. Because the sooner you do it, and that's the same with
pain.
Agreeing with what the property pool is as well, isn't it? Once you've got a property pool agreement and that, this is how much we all have combined.
This is how much the house is, this is how much. Yeah.
And it's easier to negotiate.
Absolutely.
You can't really negotiate until then, but somehow people do.
That people try to.
Yes.
And I have had cases where I've inherited the case usually. I remember one where I did it. My client wanted. So we agreed to 50-50. And I thought that was the end of it. This was years ago. And then they started moving the goalposts on what the property pool was, 50-50 of what. And so we had just as big an argument as if I hadn't agreed or my client hadn't agreed to 50-50. So, be careful with those sort of things.
Yes, definitely. Okay, number 2, and we bring this up a lot.
Yes, we do.
And one of our members actually went to mediation recently and used this rule and finally finalised their mediation.
Oh, great.
Furniture.
Yes.
So tell us, anybody who's listening who wants to keep their divorce not expensive or their property settlement not expensive, what is it about furniture that makes it expensive?
Because there's so many bits of it to fight over, and it's not a legal thing. So don't do furniture fights, because I've seen lawyers writing massive big letters with checklists and inventory of stuff and, the esky in the laundry, oh my goodness.
And how much would a letter like that cost?
Oh, well, a fortune. Yeah. If it's a few pages,
yes.
Even if you've compiled the list, it's still a big letter. The other side writes it. And gets it, and then they write back and respond, no, that microwave was mine from when I lived in the flat. And really,
by the time you've argued that, you've probably spent more money than it's worth.
Absolutely. And like I say, it's only secondhand furniture anyway. So if you can't agree on furniture, let it go.
Yeah, and you've said that you've seen it, people go to mediations and they spend the whole day arguing about furniture, who gets the towels, who gets the plates. And then what happens is they don't ever get to the important things, like how many days did that child spend with each parent, or who gets 50% of the property pool, that kind of stuff.
So that would never have been my client, I have to say. They keep track of what's important. But the other side throws up these little barriers, and they try to find sometimes the things that you really love to put in there. So the court has dealt with it a few different ways over time. But imagine getting to the trial and still having issues with furniture. The court's attitude basically is we can't be bothered.
Yes.
You do 2 lists, mum, or the applicant, roughly equal. You, the respondent, choose one of those lists. That's the end of the furniture.
Yeah.
So unless it's amazing, antique, not insurance value, but it's really got to be something really amazing. I do know, like, if it's an inherited piece, it's handed down through the generations, yes, argue over that by all means, but not the second microwave, the lounge chairs. Don't.
Or the second best dinner set, or
don't
the cutlery.
go there. Yeah, because just call it minimalism and step into your new future without it. It doesn't really matter.
And for the cost of arguing it, you probably could have gone and bought yourself a new set.
Well, you could certainly have bought yourself a whole second-hand house full.
Yeah.
Yeah, and maybe you don't want those memories. You know?
And look, I know it sounds heartless because, like you and I are not going through a divorce right now, but, we've both been through it, and we both know that you're attached to, like, the cutlery that you've always used since the kids were little, and every time you look at that little spoon, it reminds you of when little Johnny had pasta for the first time, or there are those memories attached to those things, and I get it can be super emotional, but if your end goal is to do a divorce as cheaply as possible, this is definitely one of those things to let go.
And also too, by the time you get to my age and older, I'm starting to worry or think about what sort of stuff am I leaving for the children, and you guys don't want the spoon that I used to feed Cameron his vegetables, or, so stuff that I thought was vital in my 30s and 40s. Now I'm saying I need to let that go because, we're downsizing or whatever.
Yeah.
And so, it's not for the kids. It's really for you.
Yeah.
And these days with digital photos, we do have a lot of memories in the photos. So take a photo of it. And if they've got it, it's not worth arguing over. They probably only have it because they know you want it. So that becomes your sort of weak spot in negotiation.
All right, so that's a bit of a hard line there, but it will help. Okay, number 3, Mum, is educating yourself to know you're asking for something reasonable.
Yes,
so
absolutely.
Explain this. How does this save you money?
Well, it's 2 things. It's educate yourself so you know what you're asking for is reasonable. Because if you ask for something unreasonable, they're going to argue back. Of course they are.
And when you say really reasonable, you mean legally
in the
allowed.
Law. Yeah, in the law. But similarly, as much as you need to keep your requests reasonable and within what the likely outcome is in law, so as not to start a big fight for no reason, if you're going to lose it anyway, you also need to be educated so if they put an unreasonable proposal, you can write back to them and go,
that's not going to happen.
The legal equivalent of, are you kidding?
Yes.
and put quote cases back to them or whatever, or what the law says. But just don't get into those little fights over what's reasonable, and don't sort of say, I'll ask for 80%, I can always come down. Because like we were saying before, the order that you're seeking, order that you want, says that you want 80% of everything, a couple of other things usually, and then it goes, and that the other person pays your costs. And the effect on the person receiving that is galvanising, really shocking. Yeah. And they're not going to be able to see past the costs and the 80%, and therefore they'll form the view it's not worth arguing over. And really, if you go to court, your lawyer probably has told you a figure that you should be reasonably asking for, and had you put a reasonable amount, you might have been able to have a proper dialogue.
And settle outside of court.
That's right. But once you freak the other person out, then they're fighting tooth and nail. So they're going to put in a counter proposal, which is way, way too low. And then the gap is expensive to fill in. Yeah.
So basically what you're saying is know what's reasonable, know what you probably should get according to the law, so you're not insulting the other person. It's like saying, let's sit down and negotiate, but first I'm going to call you a lot of names and tell you don't deserve anything.
Yes.
And then I hope you're reasonable from the rest of this discussion and we can come to an agreement. They're not going to come to an agreement.
No, they're not going to come to an agreement.
So it's not like making a negotiation in a sale of a house.
You're not buying a used car.
No, you're not haggling at the market.
No.
You're trying not to upset them at the same time as get what's fair.
Absolutely. So it's respectful communication between the both of you. And it is possible, of course, to have different views on what the proper or what a reasonable proposal is. But keep it real. If you're wanting like a much higher amount than they seem to think, be prepared to put your reasons with the documents that you've collected in item 1 here so that you can say, well, no, because I had this much in the bank to start with and here's the proof. Because, my mother owned the land or whatever and here's the proof, And so that you they may go, oh, I'd forgotten about that. Or they might go, oh, she's on to me. I can't argue that anymore. Okay.
Yes.
But whatever. It's just don't be unreasonable. Keep it real. Keep it factual.
Yeah. So if you're asking for something that is never, ever going to be given to you by a judge, you're wasting your money. If you ask for something that's going to fully insult them and is nowhere near what the estimated amount that your lawyer or their lawyer has given them, they're going to be insulted and you're going to end up inflaming the situation and probably not negotiate or settle outside.
Absolutely. It could cost you tens of thousands of dollars.
And so it's all about educating yourself. And I think, Mum, things that we've noticed over time is once you are educated, like our members and listeners, they feel a bit more empowered.
Yes.
And they feel a little bit more certain and sure about themselves. So when they are negotiating, it's not
they're not defensive.
Could you please give me this? I think it's
no,
right.
We're entitled to this.
Whereas now they're going, I'm entitled to this, so this is what we're going to be negotiating.
Yes.
And it comes across more genuine that you're not going to be playing silly and you're not going to be playing pussyfooting around.
I like the idea that many lawyers are going to be confronted by our very educated, confident women and men. But people who are educated, we do help a lot. Actually, that's interesting, isn't it?
Yes.
I shouldn't say women. It is. We help a lot of men as well.
Yes.
But the same thing. If you're going in there self-represented into a mediation, you need to be educated. You need to have your cases at your fingertips. You need to know what they're talking about as well as why you're asking for what you're asking.
Yeah. Okay, so get your facts as soon as possible. Prove it with evidence. Don't waste your time on furniture. It's going to cost you more than it's worth. Make sure you've educated yourself on what the law is and know that you're asking for something reasonable and you're not going to upset them or insult them. And then the number 4 is hunting documents.
Yes.
So how does hunting for documents, what does that mean and how does it affect?
It means...
Did you know you could find us on Instagram, Facebook and TikTok? We're there waiting for you right now. If you want to get more out of the Divorce Course, all you have to do is go to the Divorce Course Podcast at Facebook or TikTok or the Divorce Course on Instagram. There we share bite-sized pieces of information and bite-sized inspiration and motivation to help you through this difficult time. Come and join our community and let us know you've joined. We'd love to see you there. And the number 4 is hunting documents.
Yes.
So how does hunting for documents, what does that mean and how does it affect
means
a costly divorce?
So it's not you going through your filing cabinet or in one client's case, the garbage bags in the ceiling up through the manhole.
Whoa.
One for each year.
That's a story.
Great filing system.
Not really, no.
You only needed it when you needed it, you sorted them out apparently.
Oh,
if you didn't need it, they just sat up there.
Huh.
But anyway, so apart from that.
Don't do that.
No, don't do that. But no, it's getting lawyers to ask the other party for this document or that document, or even you writing and asking, I haven't got the bank statement for May 1996 to October 1997. Now, if they've given you disclosure, and 97 and 96 is a big extreme. I mean, it really should be only the last year or two, but something critical may have happened back then. But if it hasn't, why would you do that? Are you trying to find out if they actually took their girlfriend to Hong Kong with them that trip? Or Or are you just wanting everything to line up and there's a gap in all of your audit, all of those? I haven't got that one. Make sure that every document you request, there's a reason for it. I want this document because it will help me prove my contribution to the, or I want this document because it will prove my phone bill or whatever that I rang 3 times that day. So you need to have a reason for most of the stuff. The new family law guidelines, family law rules, set out what's expected to be reasonable for disclosure, and it's only like 12 months of statements, and it's got a whole list of things. It's all in the central practice direction and in the schedule.
And we've done a checklist in our course that's not out yet.
We have the one we're trying to write.
Yes, the self-rep course.
Yes. So just keep those documents to a minimum, because when you get documents, they have to be read by your lawyer, otherwise he might miss something or she might miss something. And then they have to be filed and recorded. They may turn up in court, and the more documents, frankly, the bigger the case. So keep it on the pivotal points. That's right. The bigger the case, the bigger the costs, and the more there is to argue over. So if you don't need everyone for that year. You just maybe you need 3 months worth just to check on something or to prove that it was you paying such and such. You know what I mean? It's just keep it sensible. And I find, with all due respect to some lawyers, they are the process of discovery and disclosure becomes all the case is about. And I think that people lose sight of the end goal and what it tries to point. So I would be saying to my listeners here, if there's a document being sought, looked after, then ask yourself, what does it prove and what does it matter? And if it's just for the principle of the thing, well, just let that one go, because you can't afford that.
Yeah, and this is general advice only, because, of course, there could be something. We don't want to say don't.
No,
but again, it's if you want to keep your case cheap and you don't want to end up spending millions like Strawn, then you need to be practical about it.
And strategic.
And every piece of paper, every thing, that lawyers will charge you for photocopying it, which blows my mind that photocopying
and reading
exists.
it again.
Reading it, putting it in a brief for the barrister. The barrister will read it.
Sending it to the other side if it was from you.
Yep.
They have to read it when they're preparing for court. It might get attached to an affidavit, but unlikely, because it doesn't prove anything.
But if you end up with, like, I know when I went to court, I saw these people pushing like big trolleys of boxes and boxes of documents, and you just think, holy moly, that's a lot of reading and really, a lot of dollars.
And really, the principles, as our listeners will know, and the people who've done the course or doing the course will know, it's not that complicated.
No.
And so it shouldn't be necessary. You can't tell me that every document in those trolleys was necessary to resolve the issue of maybe contributions or future needs or whatever. It just isn't. It doesn't sound feasible. So I'm grateful and thankful to say that we've never had a case that involved a trolley.
Well,
we don't own a trolley in our firm.
I'm glad, Mother. What that also confuses me anyway. Why don't they have it in the digital form? It's ridiculous. There's carting paper around. What are we in the Stone Age?
Well, yes. Well,
yes.
It
is in the Stone Age.
When you're making submissions to the court and you need to be able to put your finger on several things at once, you really can't beat the paper version.
For old people, yes. I'm just saying, Mum, the new world.
My submissions are always on my iPad.
I know, yes. But paper.
But I for years had a black cover on my iPad so the judges didn't know I was using an iPad.
Okay.
You'll see more proactive lawyers now. And for years, the court was built in 96 and it had those telephone cables for the old-fashioned way of computers.
Oh, wow.
But there were many judges who said, don't turn those things on in here, And so it's taking a long time. And until, I think, to be successful, you need to do like they do, I think, in the Supreme Court in Queensland, the lawyers have several screens in front of them and a few documents open at once. But yes, so we digress. So
hunting documents.
For the sake of it.
If you're just hunting it for the sake of it, and look, don't get me wrong, I think in the post-separation abuse world, I feel like some I've seen it through our members. Some people are just chasing it of their exes because they want to see what they've been doing. And they want to read their bank statements to see where they go, what they do. So, if you're in that space where you're like, I don't want to have to give my bank statements over because they'll know what gym I go to, or they'll know. So you can always think of other ways around it and look at the rules. But if you're the person who's got a lawyer who's getting documents that date back to
pull them up. Stop
forever. Just go, why are we doing this again?
Yes,
and is it worth the money?
And remind them the central practice direction says that such processes need to be proportionate. So if you've got a $30,000 pool or a $50,000 net equity in something, don't spend $10,000 getting the documents on it. You might as well just settle it.
Is it the same for subpoenas? Like if people are in court, there's a certain amount of subpoenas you're allowed to have. And say they subpoenaed, I don't know, I'm trying to think of an example, the records from the doctors for the past 4 years. Like would that...
It's only relevant if the health of a person is relevant.
But would that cost a lot of money because someone has to read all the notes?
Yes. And also don't forget the doctor will probably charge to produce those documents. So again, targeted subpoenas are important. The self-represented people are not allowed to issue subpoenas without the permission of the registrar now. And even lawyers now are not allowed to issue more than 5 subpoenas without permission. And I've seen cases where there's 20, 40, 50 subpoenas. It's just obscene. And when you do a subpoena, then your lawyer has to go up to the court and read those documents, take notes, get copies, include them to the barrister. The barrister might go up and read. It's just
a lot of money.
Too many documents, too many money. So I think you can do death by documents and death by disclosure.
Yes. So you're basically saying the easiest way to rack up your bill is documents and disclosure.
And if the other side is getting all upset about you haven't given the right documents, perhaps talk to your lawyer and say, look, how about you step out of this bit and I'll deal with this because I want to keep my money for when we're actually in court and for you to actually advise me, not, oh, here's this document and here's number 2 and here's number 3 and here's number 4. The lawyer charges the same, whether they're using their lawyer brain or if they're being part secretary or, so just
part editor, I guess. They're editing and putting it together in a format to pass it on.
And they have to read it.
Yes.
Because if there's something in there that you've given them and they haven't read, they can be sued over. So you just opening a whole can of whoop-ass. Don't.
And a big scary bill at the end.
Yes.
Okay, so there's that step-in, step-out approach that you can use where, you can do that bit. Ask a lawyer if they're comfortable with that, of course. But that gets us into that next phase. And, of course, this is all general advice only because disclosure and subpoenas are important sometimes in court, so you don't go over the top with it, but, you sometimes do need to do it, but get legal advice. The last one then is don't be afraid to challenge your lawyer.
Yes.
Or change.
Lawyers.
Now, lawyers aren't going to like this, but I don't think any lawyers listen.
Them, Mona. Sack them for a month or 2 and then come back on.
I only know one lawyer that listens. And so tell me, Mum, why and how you challenge a lawyer.
I think you've got to remember it's your case and it can be run your way. The lawyer's there really to give you advice and tell you what's legal and what your obligations are, but it's up to you to give instructions. If the lawyer says you have to do this by this date, well, do it because that's probably true. Just check, does the court order say it? Do the rules say it? But you can say, why are we chasing all of those documents? That seems unnecessary. Nothing turns on that. And get them to explain it to you. If it's a really rubbish reason, say, look, you know what, don't do that. I'll give you an indemnity. But just challenge your lawyer on those things. If you know more than your lawyer does, if you've done the course and you think your lawyer's missed something like, I don't know, an inheritance or
a contribution or
some contribution,
health factors afterwards.
That's right. Or a potential payment for something, then just say to your lawyer, look, I think we really ought to include this and listen to your lawyer if they say, well, this is why we haven't. And that you might say, fair enough. But if their reason doesn't match up, then think about moving on to another lawyer. If you can't stop them with the disclosure roundabout, maybe have them sack them momentarily, do your own bit and then come back on board, bearing in mind they will have to read it, but at least they're not doing the letters back and forth about where's this one, where's that one.
And look, and just to clarify again, you do have to do disclosure. It's part of the pre-action procedures, and you can get in a lot of trouble if you don't.
Yes.
It's just the extent of it.
That's right. So the court's trying to get people to be proportionate, and judges lawyers protecting themselves probably, or out of habit, or the desire to be like perfect with disclosure, are inclined sometimes to be too pedantic about it.
Yeah.
And so I'd be asking my lawyer, what does that prove, that document?
Can you get a second opinion? So you can say to your lawyer, why are we doing this? And then can you go and see another lawyer and go, is this right? You
can. So what if you come to another lawyer and you've already got a lawyer, that the new lawyer must tell your old lawyer, unless you say, I don't want you to tell the other lawyer, I'm just getting a second opinion.
Right.
And so that never gets transmitted between the lawyers.
And that's totally fine. You do that with the doctor. If they say, you've got to have surgery, we've got to cut off both your legs, you're probably going to want to go, why? And then go to another doctor and go, do I have to get my legs cut off? Is there another alternative? There's nothing wrong with doing that. There's nothing wrong with getting a second opinion.
In fact,
with the lawyer.
I think it's a good thing.
Yeah.
The only issue is often is the complicated case is hard to explain to a new lawyer.
That's true.
But if you get an hour interview, maybe just ask them on that point. Am I on the right track here? Is my lawyer, does she really have to do this? And just sort of just reassure yourself. You can always Google, listen to us, but ours is general advice.
Yes.
But a lawyer that you go and see for a second opinion can probably give you more targeted advice about if you're on the right track.
And does having a family accredited specialist, and now this isn't an ad for you because you don't want to take on any more clients really, but is it getting a family law accredited specialist, does that make your divorce more expensive or can it make it cheaper?
Well, it does make it expensive because our hourly rate is higher. But I like to think that our experience means we don't take as long to get to the point, as I just did then.
Yes.
Sorry. Yeah, and also sort of you can just call bullshit on the other side's arguments straight away because we know, hang on a minute, you can't do that because of Zick and Zick, this case or Rob's case or, so that these people are the bomb. And the way I got into family law as an accredited specialist was that I was once a general practitioner. I did everything when I was young, when you were little. And I did conveyancing, I did franchising, personal injuries and family law and wills. And one day I was trying to get another lawyer to make an offer to my client. So I rang him up and was just sort of trying to encourage him to make an offer, and I'm dropping hints that my client might be interested in an offer. And he didn't move a bit. He told me a few cases and he really put me in my place nicely. I hung up and I thought, I didn't do my client any good there. And then I looked him up and he did nothing but personal injuries cases. And so he just chewed me up and spat me out. And that was the day I decided I had to be a family lawyer only, because on family law, I was
chewing up and spitting people out.
But I couldn't be top.
You can't be good at everything.
And so in this time of specialisation, no one gets their feelings hurt. If you've got a general lawyer who looks after your wills and that you go to for a car accident or whatever, motor vehicle crash, they would not get their nose out of joint if you go to a specialist family lawyer. And I just think specialist family lawyers, if the other party's got a good lawyer, your case will be cheaper.
Yes.
Because if there's two people who know what they're talking about, they arrive at the conclusion pretty quickly.
Do you see non-specialist family lawyers in the family court getting yelled at by judges?
No.
You don't?
When I went to do family law early on, the word was it's very cliquey. That all of the judges know all the practitioners, and there are a lot of things that aren't explained that you can get wrong. I think that used to be the case. Now the case is, I think, that you can find out what you need to know before you go there, and there should be uniformity. And, of course, it's a bigger profession because I joined law about 7 years after the Family Law Act came into play. And so it was a small court and small practice. Now it's a much bigger routine. But I think it would be a common experience for a non-family lawyer to maybe not understand something and, or be up to date maybe.
Yeah.
So it's what you can afford, I guess.
Yes.
But if you're going to have a person who doesn't just do family law, you need to educate yourself so that everything goes through to the end.
Okay.
Yeah, properly.
Right. So the 5 things that you need to do is get the facts and have that evidence as soon as possible to stop the ping pong letters, stop the furniture problems and fights because it's just going to cost you more than it's worth, even though it's sad. Educate yourself and know that what you're fighting for is reasonable.
And what they're looking for
is reasonable. So you're not wasting your time over that argument. Hunting for documents for no reason is going to cost you a lot of money. And don't be afraid to challenge your lawyer.
Yeah.
Or change or get a second opinion.
Yeah.
And if you're interested in any more lawyer kind of things, we have a red flags episode on lawyers.
Yes.
And we also have on our Instagram how to choose a lawyer based on their divorce personality type. And, of course, in our course, the DIY Divorce Blueprint, we talk you through how to choose a lawyer based on their personality type and what you should be looking for. And
not the lawyer's personality.
No, but we do talk about their personalities because sometimes that can clash. So be really mindful that there are a lot of pieces to the puzzle. And if you put them in together in a certain way, your divorce outcome is going to be expensive. But if you put it together in another way, in a smart way, you can avoid being like Strawn and Strawn.
And the family law courts actually have now a smarter divorce. They've got little booklets and things.
Great.
So they're encouraging people to be mindful of costs, not to just blindly follow the sort of discovery path or the arguing path.
Yeah.
And there are cost consequences if you're asking for something that's not reasonable
or
the other person's asking. So when you get to court and what they've asked for is like weirdly out of whack, the judge may make a cost order against them or their lawyer
Which means they have to pay you money.
Some money. They won't pay all your legal fees to make up for dragging you all that way for no reason. And don't forget, you're putting offers in all the time, keeping a reasonable offer, and you can refer to that as in your arguments for costs. At the end. So.
Well, it could be more costly again if you get done for costs and the judge says you are unreasonable.
Yes.
What you're asking for is unreasonable. You've wasted the court's time. Now you pay some of their legal fees.
Yes, that's right, because they made a reasonable offer way back in February 2023 and you didn't accept it.
And we've got an episode that I'll put in the show notes called Costs and Calderbank Offers. Calderbank Offers. So if you want to go listen to that, if you're worried about getting in trouble with that as well. Thank you, Mum, so much for your time.
You're welcome.
And anybody who's listening, we are going to next month choose another lucky reviewer on our Apple Podcast, write a review, and we'll call you out in our show. Obviously not your real name, but the name you use. But thanks everyone for listening, and thanks for coming, Mum.
Bye everyone.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording